Two people are dead. One man is on trial for both killings, and the evidence sounds devastating. Blood on his clothes.
A witness who says Banfield gave the orders.
Experts who say the scene was staged. But here's what most people don't know.
The detectives working this case didn't agree on what the evidence proved.
And when investigators themselves disagree, a jury doesn't have to choose a side. It can stop, and that's why this case, no matter how dramatic it sounds, may never reach a unanimous verdict. Stay tuned because the story is shocking. Brendan Banfield, a former IRS agent and investigator, is on trial for the killings of his wife, Christina Banfield, and another man, Joseph Ryan.
Prosecutors say Banfield was having an affair with the family's au pair, Juliana Perez Magalhães. Prosecutors also introduced evidence about the nature of that relationship, that after Christine's death, the au pair moved into the master bedroom, that a photograph of the two together was placed on the nightstand, and that the couple's child, at times, referred to her as mommy. They also alleged the two used a BDSM catfish, creating a fake profile on FetLife while posing as Christine, to lure Ryan to the Banfield home.
Ryan believed he was meeting Christine for a sexual encounter, and according to the state, Banfield was waiting nearby at a McDonald's so he could return quickly.
Prosecutors say when Ryan arrived, the au pair called Banfield.
Ryan was shot, Christine was stabbed, and prosecutors say the scene was staged to make it look like Ryan was a violent intruder and Banfield the responder.
Magalhães took a plea deal. Banfield went to trial.
Now the prosecution's case. The government says this case isn't about chaos. It's about control.
They presented blood spatter testimony showing cast-off blood on Banfield's jeans. Evidence they say is consistent with active stabbing, not emergency aid.
They argue blood on Ryan's hands was transfer, not defensive, suggesting staging.
Prosecutors also showed that Banfield and the au pair practiced at a shooting range in late 2022, and about a month before the killings, he purchased the firearm used in the shooting.
And they rely heavily on Magalhães' testimony, describing Banfield as the decision maker.
If a jury trusts these experts and this witness, this case convicts.
Let's turn to the defense case. The defense does not deny the tragedy. They attack certainty.
They argue Magalhães is not a neutral witness. Her freedom depends on her testimony. She was originally charged with murder, later pleaded guilty to involuntary manslaughter, and prosecutors are expected to recommend time served in exchange for her cooperation. Prosecutors say there were two murder weapons, a gun and a knife. The defense points out that Banfield's DNA was not found as a match on the knife, and that expert testimony described the results only as consistent with, not an identification. They challenge the blood interpretation and offer alternative expert testimony on it. And they called their own digital forensics witnesses to dispute the prosecution's conclusions about the online evidence. And Banfield testified himself. He says Christine didn't know about the affair, did know about past infidelities, denied any plot, and said the morning was normal, an expected zoo trip for the au pair, and no plan to lure anyone to the house.
Now the cross-examination. Here's where the case becomes unstable.
The jury heard that detectives themselves disagreed about major premises of the case, including whether the digital evidence actually supported the catfishing theory at all.
But the fracture doesn't stop there. The prosecution's case rests on a cooperating witness, a witness who was originally facing murder charges herself. That doesn't make her testimony false, but it does give her everything to gain and nothing to lose. Jurors are allowed to consider that. They're instructed to weigh testimony like that with special care.
Once a defendant testifies, the case becomes personal. If jurors think he's credible, doubt grows fast. But if they think he's shading facts, the state's theory hardens.
Now the law. The law does not ask jurors to choose the most dramatic story.
It asks them to agree unanimously that guilt has been proven beyond a reasonable doubt. Every juror, no exceptions. Also, jurors are instructed to consider whether a witness has received a plea deal or expects leniency, and to weigh that testimony with special care.
If the evidence depends on expert interpretation, credibility calls, and a theory not even investigators agreed on, the jury is allowed to hesitate. That hesitation isn't confusion. It's the burden of proof working exactly as designed. Let's turn to my ruling. Before I give my ruling, one important note. This trial is still unfolding. It's expected to wrap up in early February. What follows is a snapshot. How this case looks right now, based on the evidence the jury has seen so far. If I were sitting as a juror today, applying the law as written, my vote would be not guilty. Not because the evidence is weak.
The blood evidence matters, the shooting range evidence matters, the post-crime conduct matters.
Yes, this is a serious prosecution, but criminal trials aren't about whether the evidence is troubling. They're about whether guilt is proven beyond a reasonable doubt to every juror. And at this stage, that burden hasn't been met for me. The state's case depends on three things lining up cleanly.
A cooperating witness whose freedom depends on her testimony, expert interpretations that are actively contested, and a digital theory that investigators themselves did not uniformly agree on.
And any of those could be overcome. All three together create lawful hesitation. Not suspicion, not sympathy, reasonable doubt.
The prosecution's central witness didn't testify from the sidelines. She testified from inside her own case, with the outcome already negotiated. By the time she took the stand, her freedom depended on whether the state won.
Yeah, some jurors will be convinced by this case. They'll credit the witness. They'll trust the experts the prosecution put on. They'll see planning and intent, but others will stop short because the incentives are overwhelming, because the experts disagree, because the investigators did not speak with one voice, and because the law does not require jurors to resolve uncertainty when certainty never fully locks in. And when 12 jurors bring different thresholds of trust into a case like this, the most realistic outcome isn't a clean conviction. It's a hung jury. If you found this breakdown helpful, hit like and subscribe. It really does help the channel grow. And always remember, the truth matters and so does reasonable doubt. See you in the next case.